Good afternoon, distinguished participants. I am Ahsan-uz, Director, Bangladesh International Arbitration Center, BIAC. It is our privilege to host this webinar jointly with our partner, Dhaka Chamber of Commerce and Industry, DCCI. Today's theme is Settlement of Letters of Credit Related International Trade Disputes through Alternative Dispute Resolution. I take this opportunity to introduce President of BCCI, Mr. Shams Mahmud, who is also Managing Director of Shasha Denim Limited and Shasha Garments Limited, and an eminent business person in the country. Mr. Mahmud is the Honorary Consul of Ethiopia to Bangladesh, who is an LLB from the University of Hertfordshire, UK. He obtained certification of international business and finance from New York University, USA. Mr. Mahmud is also a capstone fellow of the National Defense College, Dhaka. I would request President DCCI, Mr. Shams Mahmud, to deliver his welcome speech. Mr. Mahmud.
Thank you, Mr. Azad. Am I audible? Bismillah ar-Rahman, Mr. Muhammad A. Rumee Ali, CEO of BIAC, Mr. Vincent O'Brien, Director ICC UAE and Member Executive Board, ICC Banking Commission Paris, distinguished panel discussants and business leaders, friends from media, ladies and gentlemen, Assalamu alaikum. It is indeed my pleasure to welcome you all to the webinar titled Settlement of LC-related International Trade Disputes through ADR, jointly organized by BIAC and DCCI. Ladies and gentlemen, the COVID-19 pandemic has adversely impacted global economy, including global trade. The steepest decline in international trade affected almost many large and SME businesses in the global value chain, irrespective of developing and least developed countries. WTO predicted merchandise trade declined by maximum 32% in 2020 as the global trade network was largely hurt. Despite COVID-19 stress in the global economy, Bangladesh has registered remarkably 5.24% GDP growth in financial year 2019-20, backed by strong economic fundamental and resilience withstanding economic shock. Despite slowdown in the global trade, total merchandise trade of Bangladesh recorded USD 84.67 billion. In the pre-COVID time, Our trade had a consistent growth spree, registering 9.5% growth in financial year 2018-19. We expect international trade of Bangladesh will rebound strongly in 2021, withstanding COVID-19 economic fallout. Ladies and gentlemen, in the ever-changing global economic ambience, trade-related disputes are emerging. Our growing international trade comes across various challenges, including inadequate port service, freight, higher lead time, customs compliance, non-payment, and non-compliance of LC. LC-related disputes are evident, quite large among these core challenges. LC is the most widely used instrument in international trade transactions in Bangladesh. In tandem with economic growth and also the international trade, LC payment disputes also increase. The common causes that trigger LC-related disputes are non-payment, late shipment, low creditworthiness, undue discount on imported products, business insolvency, third-party guarantee, and documentary discrepancy. The breach and default in LC settlement adversely affect credit rating of banks, risk exposure, doing business environment, international trade competitiveness. The rate of import LC dispute is relatively high in Bangladesh. The non-payment rate in back-to-back LC against a master LC in RMG backward linkage industry is escalating, despite stern guidance of Bangladesh Bank. It is worth mentioning that slow global trade trend and fiscal stress on business heightened the LC non-payment disputes in the pandemic time as an added concern. Ladies and gentlemen, to quickly settle international trade disputes, businesses usually prefer resolution through mutual discussion. Under this arrangement, importers take the advantage of negotiation, putting pressure on exporters for settlement. Stakeholders of LC disputes are found least aware of the availability and benefits of institutional ADR process through arbitration and mediation. A recent survey of Dhaka Chamber of Commerce and Industry found 73% of businesses with difficulties of contract fulfillment prefers mutual settlement, whereas only 3% prefers ADR. To resolve trade dispute and restore the business confidence, we prioritize efficient, effective, and time-bound resolution process promoting ADR under institutional management. I appreciate BIAC as a trendsetter and pioneer in promoting effectiveness of commercial ADR among various stakeholders like government, financial institutions, large and SME businesses, Bangladesh Bank, intending firms, traders, lawyers, and ADR professionals in Bangladesh. Ladies and gentlemen, dispute prevention and effective dispute resolution are critical to mitigate risk profile and improve credibility of the businesses. High cost is associated with international trade dispute resolution services due to different legal frameworks, cultural and language barriers, which mostly do not help our businesses. BIAC, in association with the other regional dispute resolution institutions, can be strong and play shared roles to resolve international trade-related disputes, including LC payment settlement. LC involves different parties, including importers, exporters, and banks. In few instances, it came to the surface that local banks delayed in clearing payment to the counterparts. A study of Bangladesh Institute of Bank Management found proportion of complaint against LC has increased along with overdue bill of entry and unsettled cases of trade transaction. Knowledge gap of the local traders, bank officials on LC clauses, and inappropriate use of terms that also causes LC settlement disputes. Discrepancy in LC document often happens as the terms and conditions of LC are not aligned with the articles of Uniform Customs and Practice of Documentary Credit and International Standard Banking Practice, which led to LC non-confirmation by banks. The weak relation of local, commercial, and foreign banks, an increasing number of LC non-payment issues, charge importers additional LC confirmation fee and third-party foreign banks guarantee, increasing import trade cost. The third-party guarantee is mostly required to import capital, industrial machinery, edible and fuel oil. Local banks can play important roles to reduce LC-related complaints by replicating international best practices and heighten institutional relation with foreign banks. I feel that reforms are needed in Arbitration Act and ADR-friendly legislations so that international arbitration cases from abroad also can be held in Bangladesh to facilitate stakeholders for our trade growth. Indeed, international trade growth will ease our transformational economic visions by 2041. Ladies and gentlemen, I will not prolong my speech. I believe our expert panelists will enlighten us with valued insights on this important agenda. In conclusion, I would like to thank again all distinguished guests and participants for joining this timely event. Allah Hafiz. Thank you.
Thank you, sir, for your enlightening message. We have learned from you lots. I would now request our moderator to take the floor, before which I would like to introduce Mr. Shafayat Ullah, who is a well-known lawyer and banker and also head of Group Legal Affairs Mutual Trust Bank Limited. He is the founding partner of Chaudhry and Ullah Law Chambers. He is a barrister at law from the Lincoln Inn and advocate Supreme Court of Bangladesh. Mr. Shafayat Ullah is an expert in commercial disputes, insolvency and bankruptcy, corporate finance, taxation, banking, and financial institutions, and is also in commercial mediations and arbitrations. Mr. Shafayat Ullah, the floor is yours to moderate the session.
Thank you. Thank you, Mr. Ahsan-uz, for a wonderful and generous introduction. A very warm welcome, everybody, to this wonderful endeavor of Bangladesh International Arbitration Center, BIAC. This is actually the seventh webinar of the series of webinars that BIAC is holding in order to promote alternative dispute resolution through arbitration and mediation, and also to create awareness in mass level. So huge commendable responsibility that BIAC has taken over, and this is the seventh segment of it. So I warmly welcome all the participants along with all the audience who are here in Zoom and also currently listening to us in Facebook. Now, without further ado, I would like to now go on to the first speaker. Now, we have got quite a few esteemed panel of speakers, and we would like to learn from them about international commercial LC-related dispute settlement, what is the current scenario, and how they wish, what are their suggestions, what are their observations, and then we'll try to kind of go into a Q&A session later on. Now, the way I would like to have this session is kind of like free sharing of knowledge and views and ideas. But because we have plenty of speakers, I would like to very humbly remind our speakers, esteemed speakers, that you have about 7 minutes to finish your first constructive line of speeches. And then when we go on to Q&A session, we'll try to give you time again. So without further ado, I would like to first of all invite our first speaker of the day, Mr. Ahsan-uz Zaman. Mr. Ahsan-uz Zaman is the Managing Director and CEO of Midland Bank Limited. He also worked for Mutual Trust Bank Limited as additional MD and Bank of America in New York at its Global Wealth and Investment Management Division. He served JP Morgan Chase Bank and Morgan Stanley and ANZ Greenlace Bank. Mr. Zaman had his MBA from the Institute of Business Administration of University of Dhaka and is an accredited mediator. He received credit training conducted by ANZ Greenlace Bank in London, Melbourne, and Mumbai. Ladies and gentlemen, it's my proud privilege to present for you today's first speaker, Mr. Ahsan-uz Zaman. Sir, floor is yours.
Thank you, Barrister Shafayat Ullah, for that wonderful introduction. Honorable President, Dhaka Chamber, Mr. Shams Mahmud, Honorable CEO, BIAC, Mr. Rumee Ali, Director BIAC, Mr. Ahmad Hussain, distinguished panel speakers and participants, Assalamu alaikum and a very good afternoon. At the outset, please allow me to mention that I do not consider myself to be an expert on trade dispute matters by any stretch of imagination. However, I am a generalist in my capacity as a banker who has to use the provisions of trade regulations and practices to support clients who engage in trade transactions. Every company would like to do business without encountering disputes with their counterparty, but it is not always possible to avoid situations where the importer and the exporter disagree. When disputes arise, they can be time-consuming and costly, but they are a reality of doing business. While most trading partners enter into a contractual agreement with the best of intentions, disputes arise which can have serious consequences. Disputes can result in the importer delaying or defaulting on the payment, or the exporter violating the contractual terms of delivery. Two main types of disputes can occur between parties engaged in international trade finance. First, financial disputes arise when counterparties disagree on the amount outstanding amongst themselves. Second, contractual disputes arise when the counterparties contravene signed contractual agreements. The process of examination of documents under the documentary credit often results in difference of opinion as to whether the documents are compliant, and if they are considered discrepant, which discrepancies are applicable. Some discrepancies will be quite obvious and known to the presenter. These are generally resolved by submission of a new set of documents or the correction of a document, or by the applicant providing a waiver that it is acceptable to the issuing bank. For some, the arguments and disputes that arise are so strong that an external source of decision maker is required to help determine who is right and who is wrong, and that is where dispute resolution comes in. While litigation has been the traditional way of dealing with disputes, there are strong reasons to consider alternative dispute resolution, ADR, for reduced costs and decreasing the time to reach a resolution. As a best practice, parties frequently enter into arbitration agreements to predetermine the details of how to resolve potential future disputes. Much attention is being turned to solving international trade disputes using ADR methods. Alternative dispute resolution offers a means of settling disputes without resorting to commercial litigation, aiming to resolve disputes in a way that is less expensive, faster, and more predictable than adversarial litigation processes. Arbitration remains the most popular method for resolving international trade disputes, but mediation is growing in popularity. Clearly, greater awareness on the use of various arbitration and alternative dispute resolution mechanisms will lead to a stronger and smoother trade and to more transparent and efficient business environment. Now, when it comes to international trade dispute resolutions, the International Chamber of Commerce, they have the documentary resolution expertise, which is called DocDex. ICC's DocDex service, which commenced in October 1997, was applicable only for disputes relating to transactions subject to uniform customs and practices of documentary credit and uniform rules for collection. In March 2002, the scope of DocDex was widened to include transactions subject to documentary collections and guarantees and demand guarantees. In November 2014, the Banking Commission approved a new set of DocDex rules that additionally caters to transactions subject to standby letters of credit and also trade finance transactions that are not subject to ICC rules. Today, the DocDex service offers bankers and traders a means to settle trade disputes, usually within 2 to 3 months or less. The key advantage of DocDex is that parties can stay out of court and settle a dispute reliably, quickly, and at a low cost. The ICC International Center for Expertise, a unit within the Secretariat of the ICC International Court of Arbitration, administers the DocDex process. DocDex offers a system whereby experts carefully examine all documents before reaching a decision. A panel of 3 impartial experts decides the cases. The center selects each expert after carefully screening to check their qualifications and independence. Experts include bankers, lawyers, consultants, and individuals who have dealt with trade finance issues for many years. The panel's decision is further scrutinized by a technical advisor to the Banking Commission, who personally reviews each decision to ensure that it conforms to applicable ICC rules and their interpretation by the Banking Commission, or to establish international practice where no ICC rules are applicable. Decisions are binding only if both parties have so agreed in their respective submission to the center. The ICC publishes details of the DocDex decisions periodically, although the identities of the parties are never disclosed. The purpose is to provide information that will enable practitioners to avoid common errors leading to disputes, while at the same time preserving confidentiality. It should be noted that a refusal of documents and a dispute as to whether the discrepancies are valid or not should not directly lead to a request for a doctor's decision, just the way as a bank would not immediately seek court action in the event of a dispute to decide who was correct. Now, in the Bangladesh context, the disputes that arise relate to loss of cargo, loss of export earning, receipt of defective goods, and rejection by buyer. Documentary fraud are increasingly becoming common, just as in the international field, it is happening in the domestic trade practice in Bangladesh as well. The problems are arising due to lack of understanding, use of wrong Incoterms, lack of understanding of duties of parties at the documentary tendering stage, and confusion as to the roles and responsibility of the parties involved. I would like to take this opportunity to mention a trade dispute that happened in our bank at its infancy. And this is a live case which is still going on, where we got to establish our claim on an outstanding trade dispute where we financed shipment of potato to Malaysia. We discounted the trade documents upon sight of shipping documents. Ownership of documents was with the ship captain, that is the shipping lines, who held ownership of the goods, and our foreign correspondent had not assigned them to anyone. Shipment was done against contract, and we filed a case against the shipping company ships in the high seas. The case was filed in the Admiralty Court, where judgments are generally swift. Arrest warrants were issued against 14 ships, and 6 were arrested off the Bay of Bengal. This happened in early 2018, and we made headlines in the papers. The shipping companies issued guarantees in our favor to release their ships for the value of the goods that they had ownership of. And this is our partial hope of getting payment against our claim, apart from the ongoing claim that we had against our client. In conclusion, I would like to make a few recommendations for consideration. That is, it relates to local inland LCs as well. Pursuing for incorporating ADR clause in the sales contract, both international and domestic, trying to incorporate ADR clause in the inland LC. Third, formulating new guidelines for governing inland LC, opened under UCP 600. By essence, UCP 600 has been formulated to cater to the need of cross-border trade. When disputes arise in inland LC, most of the cases beneficiaries are not getting payment. Issuing bank refuses to pay, quoting discrepancies where goods under the LC have been delivered. To overcome this scenario, ADR can play a vital role to safeguard the beneficiary. Awareness program for bankers and for customers regarding the ADR process. Legal enforcement mechanism, which are often weak due to lack of understanding of trade fraud, and the mechanism used by the lawyers and other concerned to resolve the disputes. Definitely awareness around these matters would go a long way in easing trade and avoiding disputes. Thank you very much.
Thank you. Thank you wonderful for your wonderful deliberation. Mr. Ahsan-uz Zaman, MD and CEO of Midland Bank. We'll get back to you soon. Now, for the sake of time, I'll move on to the next speaker. We will discuss, we'll reflect on the speaker's statements later on, once we have heard all of them. I would like to request Mr. Vincent O'Brien, who has now joined us from Dubai. Mr. Vincent O'Brien is a member of the Executive Board of the International Chamber of Commerce Banking Commission, Paris, and Director ICC, United Arab Emirates. He is Associate Director, Institute of International Banking Law and Practice in Washington, DC. Mr. O'Brien worked as technical consultant for trade facilitation in over 100 countries for banks, development institutions, and governmental organizations. He's engaged as expert witness in international trade dispute resolution exercises. He's an advisor on innovation and market intelligence of the China Systems Corporation, global trade and supply chain finance solution provider. Mr. Vincent O'Brien, the floor is yours.
Thank you much. Thank you very much, dear friends. I will skip the formalities because I know I'm among friends, and I've been coming to Bangladesh for about a quarter of a century working with the ICC. So this is really a great privilege for me to be with you today. Now, so what am I here to talk about? Well, I'm not a lawyer. I'm not even an arbitrator, but I have a good bit of experience, significant involvement in both legal proceedings and arbitration for many years. And the role where I acted, again, not in a legal capacity or an arbitrator's capacity, but I have worked as an expert witness, having lots and lots of experience in letter of credit operations, as we heard, in more than 100 countries. So I'm trying to give you the perspective of the expert witness, how I would visualize my opinion and views on legal proceedings, and then ADR and arbitration, actually in particular, which is growing in its application phenomenally across the world. Well, keeping it simple, legal proceedings are litigation, I guess. And again, I'm not a lawyer, but I think they can be considered as the standard dispute resolution method in most countries, most jurisdictions, and also in Bangladesh. But on the other hand, arbitration comes into play by way of agreement of one or two parties. And this is where the parties will be involved in a dispute. And the idea is to seek a resolution through arbitration instead of the normal dispute resolution process that may be in place, which, as I said, could be considered as the litigation. So from my experience in legal cases and experience in arbitration, I'm just trying to give you some practical flavor of where I'm actually coming from. So again, trying to be practical, here are some of the things that I liked or I favored about arbitration. Number one, time. So generally speaking, from my experience, arbitration proceedings have tended to move faster than litigation, or should I say legal proceedings. So the speed and time, and of course we all know in this modern world, time is money. And that brings me then to actually time, which is a very important point as well. Generally speaking, arbitration proceedings, from my experience, have tended to move faster. And of course, this brings us to the cost. And again, from my own perspective, my experience has been that the cost of arbitration, the costs to find a settlement, is often less than the cost, or much less than the cost of litigation. So let me kind of give you a little bit of my experience just to support this. Let me give you an example. So I can give you an example from my own perspective as an expert witness. So only last year, I was involved in legal proceedings on an LC case, letter of credit case in the United States, in USA. And the way it worked out, I was required to be on site during this proceedings for 10 full days to be called as an expert witness. So obviously, time is also money for me. So I also charge fees for the 10 full days. But to be quite honest, my input, where I was actually gave testimony and cross-examined, only lasted in total for about 1 hour and 45 minutes. It was on a very technical point, but yet I was there for the full 10 days. However, last year as well, I was involved last year in an arbitration hearing in Singapore. For the arbitration, I was scheduled to appear on one specific day for specific hours in the arbitration. So I was there required in a schedule for 1.5 hours. Now, I must admit, at the end of the day, I got paid for 1 full day, but 1 full day is a lot less than paying for 10 days. So this tends to be the way that the arbitration also works. In terms of litigation and arbitration, another point regarding the time, the cost, now we're looking at expertise. And of course, letters of credit business is technical. Letter of credit business requires specific expertise in the subject matter. Again, from my own background, expertise as an expert witness, this has shown that the arbitrators selected by the parties for a particular case tend to have specific, focused expertise on the technical issues that is subject to this dispute. And again, it's only my own opinion, but my belief is that this leads to a more balanced and fair outcome for the parties to the dispute. The next subject is a little bit legalistic, so this is the way I see it, but I can of course be corrected by our legal colleagues here today. And this is regarding the appeal rights. You know, most arbitrations I've been involved in, the arbitration award, the award, the decision, the award is binding and binding. And in most jurisdictions, it's very difficult, or dare I say, there is a limited right of appeal. So it tends to be a more efficient system process. So in terms of focusing on Bangladesh, you know, really, look, we've heard it already from earlier speakers, so it's not me criticizing. Disputes are actually increasing, but this is not just Bangladesh. This is a global phenomenon now in terms of letters of credit. Ahsan explained the background, so I don't need to go into it. But one very important thing regarding arbitration for letters of credit in Bangladesh is that in terms of letters of credit, expertise, I must acknowledge that the level of expertise in LC practice and ICC rules is at the highest level in Bangladesh. Absolutely. We have some of your members of the Banking Commission playing really important roles in the development of ICC rules. So my final comment, to try and keep on time, I think all of this bodes well for the arbitration center, and particularly in dealing with arbitration of letter of credit disputes. So moderator, thank you for this opportunity to be with you and other colleagues, and I'll be standing by for any questions. Thank you.
Wonderful. Thank you so much, Vincent. And you have just taken 6 minutes, 32 seconds. Wonderful for that. That complements your way of saying that for you, time is of the essence, and you proved it once again. Well
Thank
done.
you very much.
We will get back to you. Now we move on to the next speaker. Our next esteemed speaker is none other than our very own Barrister Sattar. I would like to give him the floor, but before that, a very quick, very small introduction of Barrister Sattar. He was called to the Bar of England and Wales. He's an advocate of the Supreme Court of Bangladesh and head of chambers, Sattar and Company. He is a former director of Dhaka Metropolitan Chamber of Commerce and Industry. His practicing area includes corporate and commercial advisory work, litigation in banks and companies, and commercial and investment treaty arbitration. He appeared as counsel in international arbitrations under ICC, UNCITRAL, LCIA, SIAC, and ICSID rules. So, ladies and gentlemen, my proud privilege to present before you Barrister Sattar.
Thank you, Shafayat Bhai, for the kind introduction, and welcome everyone. Assalamu alaikum. Today's topic is very, very interesting, and most international contracts obviously have an arbitration clause because no one wants to litigate, and in any particular country, especially in cross-border transactions. Not only is it time-consuming, but it is also sometimes very costly. So lawyers drafting such contracts regularly try and insert an arbitration clause in the contracts that they draft. Now, arbitration is perfect for resolution of complex commercial disputes. However, with regards to disputes arising out of LCs, arbitration has fallen short, and it has not been so widely or successfully adopted as a primary means to resolve disputes across a majority of LC users. And this is because, and my thoughts are very simple. I bounced off my thoughts with some of my banker friends as well, and they seem to agree with some of my thoughts. And just as Shafayat Bhai said, that this is just like a casual conversation to put some thoughts up in the air for this further discussion later. And my thought is on this, that traditionally, I think that the concept behind a LC transaction may not ideally fit with the idea of a dispute resolution. Now, I'm coming from a different angle so that the debate later is much more interesting. And I say that is because LC is a form of a strict payment. And the very reason why parties, especially in cross-border transaction, wish to choose LC payment is to get the security that it offers. Now, having a dispute resolution may give an opportunity to the parties to raise a dispute and therefore dilute the security that LC offers. Now, as we all know, the purpose of an LC is to offer protection of payment, i.e. that the payment shall be made if the conditions contained within the LC is complied with by the obeying party. That is to, in order to receive the payment. any interference as such with the payment method by any entity by raising a dispute, personally, I think would go against all norms and customs of international banking and with international trade. Now, that's my first thought, because no one wants to dilute the security that an LC offers, and having a dispute resolution clause may, and I say may, provide an opportunity to the parties to raise a dispute and stop the payment. Okay, that's my first thought. The second thought is that LC is usually a contract between the banks and not between the underlying parties or the parties to the sales contracts. So I do not think that the banks would wish to engage itself in disputes on behalf of the parties themselves. And the bank is more concerned with as to whether it's like a strict form of liabilities, like a strict form of payment. As long as the documents are there, following the UCP 500 or 6 or whatever it is now at the moment, they would need to comply with their payment obligations. They do not want to engage in arbitration in banks, in arbitration or engage in any form of litigation. Now, that's the general trend of the banks. And the words of our Honorable Appellate Division in this context is very, very useful, I think. Is this case it's called Zaita Garments, where our Honorable Appellate Divisions had said, and I'm reading out, as soon as the letters of credit are established between the issuing bank and the negotiating bank, it becomes an independent agreement between the two banks. Neither the seller nor the buyer has any privacy to that agreement. So it is by nature a separate transaction from the sale agreement. Now, the Appellate Division further goes on to say that consequently, the undertakings and obligation of a bank to pay, accept, and pay drafts or negotiate on a letter of credit are not subject to any claims or defenses by either the seller or the buyer. So unless the banks wants to raise a dispute in between themselves, this may give a potential to, and I use the word may because I have not experienced it and these are just food for thought, may give an opportunity to the underlying parties to raise disputes. And there are other several cases as well, and we all know from the legal fraternity that an LC is a very strict area in terms of interference. So with such a wealth of case law behind us, it is very difficult to interfere with a dispute concerning an LC, especially if the dispute is between the buyer and the seller and not between banks. So at this point in time, my thought is that it is quite difficult to apprehend a dispute concerning an LC being resolved through ADR. Whereas even the courts are unwilling to interfere. However, and I'll end this with this, that however, I note that it is not impossible. It is not impossible to arbitrate LC disputes because the trend is evolving. So we are moving away from the traditional mindset that no, there cannot be any disputes in relation to LCs, because this can be seen in another decision of our High Court in the Corona Fashion case, where the High Court has identified that the use of arbitration clauses in LC, especially arbitration under the International Center for Letter of Credit Arbitration Rules of Arbitration, the Center rules in short, where the High Court division has said that nowadays, and I'm reading it out verbatim, nowadays, many of the remitting banks inscribe the provisions of arbitration in the LC and documentary collection. It has become a frequent custom to incorporate the provision of arbitration dealing with documentary collection, more particularly in dealing with transactions relating to documents by acceptance. Since the practice of documentary collection is highly specialized and often counterintuitive to the general commercial law, the judicial process has not generally afforded speedy, final, and sound relief desired by the parties to a dispute under documentary collection. To resolve this predicament, International Center for Letter of Credit Arbitration, INC, was founded in 1996, which is located in Washington, D.C., USA. So what are we seeing here? We are seeing that there is a change in the, there's a shift, a paradigm shift from the traditional conservative view of not having to arbitrate any LCs or not engaging any litigation to having small arbitration clauses inserted in the LCs so that the parties can have the scope of actually raising a dispute. Another set of rules is obviously, which our Zaman has already covered, is the DocuDex rules of ICC. However, although we shift in the trend and more LC disputes will be arbitrated in the future, I go back to my initial thought, whether it is appropriate in the circumstances to have LC disputes arbitrated, and whether if an opportunity is given to raise a dispute and arbitrate on LC matter, whether it dilutes the security that an LC payment offers. With that note, I'll end here. Shafayat bhai, thank you so much for giving me this opportunity just to share my thoughts. And I look forward to obviously a very lively discussion afterwards.
Thank you. Thank you, Samir bhai. Wonderful. And, you know, he just took a different view, which is absolutely welcome, because, you know, he has given us a good food for thought. His view is obviously he just narrated it. We will reflect on it when the second session starts. So thank you, Samir bhai, for that. Now I move on to the next speaker, who's Mr. Khalid Aziz. Mr. Khalid Aziz is the Managing Director and Chief Operating Officer of Standard Chartered Bank. He is an experienced banker. He has experience of 3 decades in information technology, banking, and automotive industries. He has remarkable exposure to finance, marketing, and sales, and human resource management. Mr. Aziz had his MBA from Stephen M. Ross School of Business, University of Michigan, USA. Aziz bhai, the floor is yours. Mr. Khalid Aziz.
Yeah. Assalamu alaikum. Am I audible? Let me just turn my camera on. Yeah. Shafayat bhai, am I audible?
Yes, you are. Please go on.
Thank you so much. I hope I'm audible. And yeah, okay. Thanks for the very generous introduction. And Mr. Honorable President of DCCI, Honorable CEO of BIAC, and all the distinguished panelists. I think my previous speaker, Barrister Samir, has actually covered a few of the points that I was going to deliberate here, right? So as a banker who has overseen operations, particularly trade operations in 2 of the 3 multinational banks operating in Bangladesh, I must say that basically disputes related to LC is separate from disputes related to the commercial disputes which are between the buyer and the seller. And I think it's very important to keep the 2 separate, right? In these many years, I have not actually come across too many cases where the 2 banks are disputing in terms of what constitutes a complying presentation versus not. And usually when that happens, it's pretty amicably resolved. And even if it gets further, you know, we do have a very good, library of ICC resources that can help us. And in an extreme case, like Mr. Ahsan-uz Zaman and Vincent mentioned, there is also the dog deck service available from ICC, which is a speedy, quite, reasonable and not too pricey service that can get in or resolve any disagreement in terms whether a presentation is compliant or not. So, so from that angle, I mean, I have hardly seen any cases where a bank has gone into court or for arbitration because they have an opposing view with another bank, right? And I think another important point my previous speaker made is basically a letter of credit is simply an instrument for settlement, right? It's an undertaking which gives the seller the comfort that if they are able to present a complying set of documents, they will be paid, and that undertaking is from the bank, not necessarily from the applicant. It's an added comfort, right? I think what I have seen, which is more common, is basically particularly for one-off transactions, capital machinery equipment, where the buyers and sellers may not be having a very long-term relationship. There could be commercial dispute in terms of the quality of the good, the performance of the good, and stuff like that, right? And this is when the things get a little bit messy. because although in terms of the presentation of the documents, it may be fully compliant, the commercial disagreement can come into the play, where it's pretty common for one party to get a court injunction or something to stop the payment or delay the payment. And this is where things get quite messy for the bankers, because my counterparty bank may have negotiated a document and I'm not able to reimburse them because there's a court injunction sitting in my local jurisdiction preventing me from doing that, right? So I think this is where, if we can use arbitration or alternate dispute resolution mechanism more widely, I mean, things can be easier to resolve, less time consuming, and it will also facilitate our reputation as a player in the international trade space. The last point I would like to add is, although basically these disputes are probably not as widespread as we may think, I think the COVID situation has the potential to quickly turn things around a bit, because there is a tremendous amount of stress in terms of supply chain, logistics, shipping, and other things, which can lead to more disputes in the future. And having arbitration agreed upon during the contracting phase between the buyer and the seller can make things a lot easier to manage. And I think this is where probably BIAC can play a role, because if BIAC can basically establish itself as a reputed and well-accepted international arbitration center, as opposed to the ones which are already quite established, like the ones in Singapore, Paris, London, or other international centers, I think that will provide a very good alternate mechanism for our traders to settle and handle any disputes. So that's where I would kind of stop for now, and maybe we can come back to it later. Thank you. Over to you.
Thank you, Khaled Bhai. Wonderful. Very short. You just finished it over in just 5 minutes time, which is wonderful. The points, as I was saying, we will get back to that. But I really liked the way you responded to Barrister Sattar. The way he actually brought up a different perspective to the discussion, and he responded spontaneously and with your thoughts. And I believe all the audience have heard you, and I also have my say on it, but I will reserve it for until we have heard everyone. But wonderfully put. I think that's the whole idea of having this discussion today. Thank you, Khaled Bhai, for your inputs. Now we move on to our next esteemed speaker, is Mr. M.S. Siddiqui. I would like to give a short introduction. Mr. M.S. Siddiqui is a legal economist and CEO of Bangla Chemical. He is a member of Dhaka Metropolitan Chamber of Commerce and Industry. He is a part-time faculty of leading university's Dhaka campus. He writes in national dailies on economics and regulatory reforms. He had his MBA from a leading university, Sylhet. So, Mr. M.S. Siddiqui, the floor is yours.
Thank you, Moderator. Mr. Rumee Ali, and also the President of Dhaka Chamber, Shams, and the fellow discussions. This LC is a very interesting subject for us, because we are facing this discrepancy over mostly for the payments of the letter of credit. It is for the import and export. For export, the exporters are very familiar with the word stock lot. Is there any discrepancy? Then they use the word stock lot, and the same customer, the importer, started negotiating the price, renegotiate the price, and take advantage of the discrepancy of LCs. And for import, I am also in international trade, so I very often I face this problem of payment. So the confusion arises. It is already discussed that the sales contract and letter of credit is two independent contracts. There is nothing to do with the export, quality of the product, date of shipment, time of shipment, or packaging, anything else with the payments. The payments related to the independent contract between two bankers in the importer side and exporter side, LC opener and the transmitting bank. But we usually mix up this many contracts. This is because of the Another reason involved here, the hidden reason is that the importers get the payment, credit, pre-shipment and post-shipment credit, and exporter also get some credit. So the bankers started talking in tune of the importers and exporters. Then the problem really arises. And we don't want to listen, we don't want to go to the rules and regulation, because when they open the LC on UCP 600, they specifically bankers mentioned that in the LC. But when there is some problem of trade dispute or a probable trade dispute, we forget about UCP 600. And the bankers usually, very frankly speaking, I find that the importer and their banker, they are friend and foe. Sometimes they work together. The bankers, local banker, facilitate the importer to negotiate, to bargain, renegotiate the contract for late shipment or quality of the product and other. Then they look for the discrepancies in the LC, and they started looking with a magnifying glass. And if you talk about the letter of credit or the contract, particularly for import in Bangladesh, thanks to Mr. Vincent, he have appreciated our police procedure. But LC from Bangladesh to other country, we usually don't follow the UCP 600. We add some additional conditions there, very funny conditions. Say, for example, shipment from Israel through Israel flag vessel is prohibited. But we put another condition that a certificate to be given that the material is not shipped in Israeli flag vessel. Again, our letter of credit asks for some more funny documents, that a certificate to be given by the exporter that they have followed all the terms and conditions of the letter of credit, unless another certificate. Now, when there is no standard format of this certificate, say for example, somebody, okay, they are very, they used to give a certificate that is, we followed all the terms and conditions of the letter of credit for preparing the document. But then recently I got an objection that they say that the document lacking the name of the indentors, their registration number. There is no reason to raise this objection, why they will write the name of the indentor or the agent of the exporters. Indentor is agent of the exporters. So these are the problem practically in our country we usually face. And this problem, the way they create it, only to facilitate the negotiation or the bargaining on credit or collection of the payment. And another problem is that when there is a stale document or document on collection basis, if there is any objection or any discrepancy raised by the importers bank, then there is this written instruction for the central bank, Bangladesh bank, that if there is a discrepancy, then bank will only release the payment after submission of the bill of entry. That means after releasing the consignment, the importer will submit the document, then they will release the payment. But according to contract or according to UCP 600 or the contract, after acceptance of the document by the importer, it is the moral obligation of the LC opening bank to remit the money immediately, but they don't do that. It's very interesting rule made by our central bank. And now, interesting enough, now Bangladesh Bank have their own platform. It's an online platform. Whenever there is a LC, they put the record information on the platform. After arrival of the consignment, the customs put the information there. After releasing the consignment, they give the import that material has been released. So all the data is available online for all the banks, central bank, customs, or all stakeholders. But interestingly, still, the commercial bank insists on submission of the hard copy of the bill of entry to the LC opening bank for the payments. So these are the disputes. Now, how to resolve this problem? These are the problem not suitable for the commercial code, regular code. Another banker was talking about the injunction. It's really, it's an instrument used by our importer in Bangladesh to stop payment for an indefinite period. And the way or the contract, the UCBC, is there any dispute between, the bankers rightly says that there is usually no dispute between LC opening bank and transmitting bank. All the problem arises from the commercial contract or breach of contract by the exporter or importer. So when the importer and exporter or the banker deliberately or whatever be the reason, or to safeguard their loan, they encourage the mix up of the commercial contract and the letter of credit, so that the matter became complex. So for all this dispute, the court is not suitable for these disputes. It should be resolved amicably through ADR. And there are some other ADR, apart from BIAC, there are some other specialized association, global trade association. They deal with the specialized product or specialized importers. Say, for example, Cotton Association, International Cotton Association, they deal with the quality of the product, payment, and agreement, contract, everything, because the nature of the product, nature of contract is different. So again, that is under ADR. So for all this contract, all the disputes, I should say the ADR is the best suitable option for resolution of these disputes. Thank you very much.
Thank you, Mr. Siddiqui, for your enlightening input, especially from, you've been speaking more from practical experience. And that was, I think, a very, very enlightening input. You've given quite a few of your personal observations. We will reflect on that. I'm sure all the other discussions will also have time to reflect on that. But thank you so much for your input. Now I move on to the next speaker, who is Mr. Shafayat Ullah. He's a barrister from Lincoln's Inn and an advocate of Supreme Court of Bangladesh. He's a member of Dhaka Metropolitan Chamber of Commerce and Industry and partner of Credence LP Law Firm. He had his LLB honors from University of London and BPT course from City University, London. Professionally, he focuses on corporate banking, land, real estate, labor, employment, and criminal matters, including white-collar crimes and writ jurisdiction. Barrister Shafayat Ullah, the floor is yours.
Good afternoon, Shafayat Bhai. It's a pleasure to be among the distinguished guests, including the Honorable President of DCCI, Mr. Mahmud. So we have had a different and diversified range of observations from our distinguished panelists. So I'll be trying to keep it in a particular sphere of model where we'll talk about why this arbitration is, what are the problems with these arbitrations that we are actually facing these days. Although we all know that arbitration is a faster and cost-effective method than going to courts. However, due to the complex nature of fraud in operation involving the letter of credit or LC, we find in practice that by taking a comparative approach among different national laws, which actually causes problems regarding these arbitrations. As we have already said that in cross-border transactions, the problem is between the difference of the governing laws. So in LC fraud, we often find it difficult to ascertain in which laws to go. And especially before going to the problems, I'd like to highlight on a few things which we practically face in this circumstance, especially with the Bangladeshi businessman. First of all, the culture of Bangladeshi business somewhat is towards not going to lawyers and by doing it themselves. So we often find that millions of dollars of deals are done without having taken any sort of advice from lawyers. So what we actually see is that sometimes the sales managers, the employees who do not have adequate legal knowledge are preparing drafts of LC which contains a lot of errors, and sometimes the LC does not does not reflect the commercial reality of today's market. Inexperienced document checkers that may raise issues and slow processes down. So what needs to be done is from both the importers and exporters that they should consult lawyers to have the clauses which they need in and having additional agreements which would help both of them keeping their interest intact. My point of discussion will focus mostly on how this arbitration could work, because before going to arbitration, we need to sort out whether we have adequate footing for going to those arbitrations. As Samir Bhai has already mentioned about Corona case, that the case was probably Corona Fashion Limited versus Milestone Clothing Resources LLC, whereby it was stated that the advising bank was not responsible to make any appointment of arbitrator. This was because of probably of the drafting of the nature of the contract, whereby it was not given a proper adequate importance that such arbitration clause would involve the advising bank in it. So in order to make sure that an arbitration could work properly, we need to make sure that the pre-arbitration or alternative dispute resolution clauses are properly given in the contracts. Because what we often see is that the LCs are being taken care of by the people who do not have neither have legal knowledge nor have proper financial knowledge. So when these people are making such drafting or preparing such LC documents, they do not have adequate support which the importer or exporter needs. So from both importers and exporters angle, it is very much essential to make sure that an additional agreement which have an arbitration clause or alternative dispute resolution clause which are properly mentioned, and it should be done in a way which protects their interest. So in many cases, we have seen that there was no arbitration clause present. So going there, we have to face a lot of problems which the businessman could easily resolve by taking expert help from lawyers, so that to ensure that they can actually make sure that their interests are protected in these LC and cross-border transactions. So what we can actually see that an error of letter of credit can have a direct impact on this payment transactions. As the earlier speakers have already said, which grounds are basically which disputes arise in the LC related transactions. So in all the cases, we can resolve before going to arbitration. We have to make sure that those clauses are there, because inadequate or improper drafting would keep especially the exporters in a position where it would be difficult for them to get their money back, and whenever a payment is refused, they can actually have an arbitration clause to try and figure out that their interests are protected. Because unless they can go into an arbitration, they cannot keep their interests protected. So as I said earlier, that my discussion point would be that arbitration, for making sure that an arbitration could be possible, we need to make sure that expert opinions of lawyers and sometimes with the financial advisors, to make sure that your contract is adequate, so that you can make sure that you can go into arbitration for LC related disputes, so as to ensure that your claims and your interests are protected. So thank you, Shafayat Bhai, and thank you all the viewers.
Thank you, dear Shahid, for your deliberation, and you have been within time, 6.5 minutes. So thank you for that as well. Yes, you have reflected on certain areas. I'm sure we will try to have a cross kind of discussion from the panelists on all of you who have spoken. Now, I'm going towards the last speaker, last constructive speaker of the day, who is none other than Ms. Rubaya Ehsan Karishma. Ms. Rubaya Ehsan Karishma is a counsel of BIAC. She handles, among other things, arbitration and mediation cases referred to BIAC. She took part in activities involving stakeholders, including IFC, World Bank Group, and Bangladesh Bank. She also worked with the STT team at the World Bank office in Dhaka. She's a Bachelor of Laws from University of London, International Programs, and had her master's in Business Administration from the University of Liberal Arts, Bangladesh. Rubaya Ehsan Karishma, we look forward to getting some real life inputs since you manage arbitrations and mediations in BIAC. Over to you, Rubaya.
Thank you so much, sir. Thank you so much, Shafayat, sir. And thank you so much, DCCI and BIAC, for providing us with this opportunity. This has been a crucial topic for discussion for quite some time. And I would like to share my experience here at BIAC today because most of the clients that BIAC has seen walk into the office have faced disputes related to letters of credit. And more often than not, we've seen them complain that they've already shipped the goods away, but they are not receiving payments, or the bank is complaining that there has been discrepancies in the documents they've submitted, the usual complaints. So when they come to us and we very normally ask them about the basis of the transaction or the contracts, what the paperwork was. So more often than not, we find that there wasn't much. It was either direct negotiation or at best there was an invoice involved. So my previous speakers have already mentioned that more often than not, the parties tend to work things out amongst themselves, and whenever they face a dispute, that's when they seek professional help. So what we're trying to say today is it is better to have an established practice. And while all disputes under letters of credit are already governed by the UCP, and we've already heard about .tex, although it's not a binding solution, but it's a very largely accepted and implemented practice. So what we would like to suggest here is, rather than going into something that would require a much larger intervention, it's going to be much easier to start with something smaller. That is, let's just try to educate the customers first. Let's encourage them to incorporate an ADR clause in their contracts, because whenever the dispute arises, it's basically them. Siddiqui sir has already mentioned that it always roots back to the commercial contract. So essentially, this is where we should work on. And having an ADR clause is already beneficial. We've heard the other speakers, including Sattar, say that the trend is evolving, that the practice is now inclining towards arbitration and ADR practice globally. So why should we not encourage the same? And this is what we at BIAC have also felt, and we recommend that the clauses should start at the roots, which is between the parties themselves, because whenever the problem arises, it's between them. And when more often than not, if you see that the other party is failing to reach the respondent, they go after the banks. But unfortunately, the bank is working at the advice on his party, on his client. So it is better for parties to start amongst themselves. And instead of relying on just basic negotiations or verbal agreements, it's better to always reduce it to a written document and have a safety clause for yourself, because it's not curtailing anyone's rights at any point. It's easier that way. And we suggest that we should take the easier route first, and also generate more awareness, because the parties need to understand that the implications of this small clause can help them in the long run. And once it becomes an established practice, we should be getting lesser and lesser cases, hopefully. So thank you.
Thank you, Rubaya. It was pretty brief. You only took about a little over 3 minutes of your 7-minute allotted time. So thank you for that as well. So now I must thank all the speakers for their first round, and I apologize for keeping the time, and sometimes I may have to, because I was under strict instruction from the organizers to keep time so that we have enough time for discussion. Now it's my time. We will be taking some question answers, but before that, may I take the privilege of just to kind of sum up of what we have heard so far from all our 7 esteemed speakers. And obviously, and then I will request the speakers to keep your videos, not just mute yourself, but you can keep your videos on so that I can take reflections from you and visual kind of hand wave. If you have to say something, you just raise your hand. I'll see you and I'll give you the floor. Just the speakers, please put the videos on. That is, I think that is better that way, so that we can have an interactive session of 15 minutes or so. Right, now we start with the first one. Our esteemed panelist, Mr. Ahsan-uz Zaman, he talked about his experience, and he talked about LC-related disputes to be settled through DocDex, which is currently the ICC recommended platform. But again, he said that incorporation of ADR clauses in contracts and LCs are important, because although we have UCP 600 and DocDex panel, but then again, as Rubaya also mentioned, these are not technically binding, because whenever there are cross-border transactions involved, these are practices which usually is honored, but not technically binding. So if one does not wish to, contracting parties, a disputing party does not wish to kind of honor the outcome, that becomes difficult. So that was his input overall. And then we move on to Vincent O'Brien. He spoke about his own experience as an expert witness. He has been called in as expert witnesses in various commercial dispute resolution, arbitrations, DocDex, and mediations, so whereby there were international cross-border disputes, and also with LC-related disputes. And he talked about, he underlined the effect of time and costs, which are correlated, because time is money. So the more efficient time management, the more efficient cost management. So that was his kind of punchline, if I may put it that way. And he was also very, very mindful of his time. He finished his constructive speech within time. He talked about that, and he also mentioned about technical knowledge, because LC is a very technical document, and he talked about technical expertise, and therefore he, in other words, indirectly or directly, actually recommended or advocated on behalf of having arbitration as a dispute resolution method, as opposed to going to litigations, because although he reserved his opinion on litigations and court proceedings, because he gave an exclusion clause saying that I'm not the lawyer. I'm sure he saw so many lawyers here, so he did his job, and he has learned that exclusion clauses are important. So he did that, but then he said what he had to say, and that basically what he said, if I may sum it up, is that many courts may not necessarily have the relevant degree of expertise and knowledge to deal with a particular technical transaction or a technicality of an LC, which is well suited by an arbitrator, and especially in an arbitration where there is party autonomy, parties can decide, the arbitrator, single arbitrator, or a board of arbitration panel who are expert in that particular field. One more thing he mentioned and emphasized, which was, he said, arbitration is more balanced and fair because it is based on knowledge and not speculation. So sometimes courts may pass an injunction without actually getting the crux of the matter, not disrespecting the court's order, but just food for thought. So that was Vincent's point. And final point he mentioned was the finality of the award, because barring some very few exceptions, arbitration awards are non-appealable, and they are final, and they can be enforced in different jurisdictions by virtue of New York Convention. So that was Vincent for you, and I think my apologies if I've not, you will have your say, but I'm just summing up what the previous experts have talked about. Move on to Barrister Sattar. Well, he brought up a new dimension to the discussion. He said, well, arbitration is good for international complex commercial disputes. It's a good way of resolving those disputes. But when we are dealing with settlement of letters of credit, international LCs, Mr. Sattar was strongly advocating, saying, well, it may not be so. He was not firmly saying it will not be so. He mentioned it may not be so. So he was just giving his food for thought. And his food for thought being, he was saying that, well, LCs are predominantly contracts between banks. And these contracts are driven by agreements between parties, supply agreements between parties, which follows in an LC. Now, LC is some way of payment guarantee, especially when we have cross-border transactions. The international supplier wants some sort of guarantee that I'll be paid and all my goods are not going to go in vain. So that is an LC. That is what he was trying to say. So he was saying, if we put, it's all right, if I have understood him right, his part of his position was, it's all right to have an ADR clause in the original mother agreement within the parties, but LC is a consequence of that. It's nothing but a security of payment. So there should not be any ADR clauses. That is his view, because he is fearing that putting an ADR clause in the LC document itself may actually trigger one of the parties or one of the banks to, and then the subsequent speakers, we have seen that banks are also related to their counterparts. So one of the receiving ends, for example, the buyer may actually try and take advantage of that and may be prompted to find a discrepancy, even if there is none. So that is his version. And other part was, he also said that banks are not related. Banks are not encouraged towards dispute resolution. They actually don't want a dispute in the first place. So why put a dispute resolution clause in an LC when strictly LC is a document between two banks? That was his point of view. I have my opinions on that. Yes, Mr. Rumee Ali, would you? I'm just summing up. Yes, I'm summing up all the speakers. I have some opinions on everything. I will maybe very, very shortly, and you can also raise hands and I will give you floor. Mr. Khalid Aziz, he talks about, he actually responded to Barrister Sattar, which was quite nice, because he was just immediately after him, and it was very candid. He spoke from the banker's point of view. He said, well, banks don't get into disputes with each other. No, banks don't want to get into disputes with each other because they have long-standing relationships. This is their business. The clients may have one-off transaction, or maybe 10 transactions, 20, 100 transactions in a year. The banks do it day in, day out. That is what they do. So banks do not wish to get into any disputes with fellow banks, with other banks. It's always related to discrepancies of LCs. That is what he figured out. He said, well, banks don't want to get into disputes, but banks are supposed to honor an LC, but the only way the issuing bank cannot or shouldn't honor an LC is when there is a discrepancy raised in the documents. And one of the conditions, as was mentioned in the LC, is not satisfied or is not concluded. So that is where the problem starts. And when there is a court injunction brought in. So that is what he said. One party may get a court injunction. He talked about it. And therefore, he again mentioned about the problems with jurisdiction. Because one thing may be okay in one jurisdiction, one court may be too inclined towards giving an injunction. The other court may not. Usually, we see in terms of supplies, when there is outward remittance issue, usually many jurisdictions courts are more inclined to give an injunction without getting into the crux of the matter, and which is also corroborated by Vincent because they are not necessarily experts in that subject matter. So that is what Mr. Khalid Aziz had to say. And finally, he also talked about ADR, incorporating ADR in the main contract as well as in LCs in order to avoid all those. And he talked about doc decks as well. But his crux was to boost Bangladesh's overall face in the international market in order to put Bangladesh up as a very credible business nation, and to put Bangladeshi banks in operation, having a very credible LC, because it's very important for international trade and finance, because there have been issues with many banks, I'm not going to name them, whose LCs are actually not accepted by the foreign counterpart. So that is very shameful and disrespectful, not only for the bank but also for the nation as a whole. So that is what Mr. Khaled Aziz spoke about, and from a very patriotic point of view, he was speaking not only from Standard Chartered Bank, he represents a very well-renowned bank, but he was talking from the perspective of the nation as a whole. Then we came to a very interesting speaker, Mr. M.S. Siddiqui, who spoke from his experience. He just spoke his experience and his long-standing experience of all those discrepancies. Again, taking from what Barrister Sattar floated on the floor. So he spoke on that issues of LC disputes only arise when there is a discrepancy. And he also spoke about perhaps a mala fide relationship between bankers and their clients, their respective clients. Now, which again should not be the case, because bankers are there to do their job. They're not there to take any partisan side in a transaction. They're there to do the job. That is ideal world, but we don't live in an ideal world. That's the problem. So Mr. Siddiqui actually referred to that and said, well, the discrepancies are there, and sometimes very small discrepancy which may be overlooked can be considered as a big one. So there comes the disputes, and there comes the necessity for an effective dispute resolution. So he also talked about the unusual requirements sometimes that banks of our country put in. For example, like something like taking coal to Manchester, because something like as obvious as all the conditions must be satisfied and there must be satisfaction certificate issued that all the conditions are satisfied. This goes without saying, because LC issuing bank will not make the payment unless the conditions of the LC are satisfied. So that goes without saying, but sometimes it is added as a condition precedent. And then the certification is also, there is no particular format. So there may be issues. So basically what he tried to talk about was if someone wants to take mala fide benefit out of it, there is room for maneuver in an LC kind of a payment. And there's room for deferring an LC payment, which is due. And that when you look at the bigger picture, does not give a very nice view of Bangladesh as a country to the international community. I think that is what he was talking about. He also talked about Bangladesh Bank online platform and their regulations. Well, we all know that in Bangladesh, LC payments, especially outward payments, are regulated by Bangladesh Bank. And Bangladesh Bank not only wants the LC documents and LC requirements, but also wants to see that the goods have actually arrived here and it's not just a paper transaction. Well, I'm not getting into certain areas because there has been some instances where there were certain paper transactions. So on paper, certain goods have been imported, which were actually not, and the money were transmitted. So these things happen, and I'm sure it's not just Bangladesh, everywhere in the world, with the growing increase in the commercial trade, these things are happening. So he was referring to that, and he was also saying that Bangladesh Bank regulations also play a role. So if something has to be done, it has to be done in collaboration with Bangladesh Bank, perhaps. That is perhaps what he was trying to aim at. Otherwise, an independent ADR and then Bangladesh Bank regulation can be an issue in terms of outward remittance. We move on to the next speaker, Mr. Shahidul Azam. Barrister Shahidul Azam talked about governing laws. Very interestingly, we know as governing law, generally it's the LC issuing bank. Governing law of that country usually prevails. But then again, there are issues. There can be problems. Some jurisdictions may not understand that. So it's actually better to have an ADR, an arbitration clause, and it's also better to have it spelled out. So basically, it's party autonomy. You can actually spell out the governing law, the arbitration law, the procedural law, and especially if you have an institutional arbitration set up, and if you put a particular deadline, then all those discrepancies can be considered. He also talked about one thing, and that is from Bangladeshi point of view, he talked about reluctance of our businessman to go to lawyers. He belongs to Metropolitan Chambers, or is it? Yeah, you belong to Metropolitan Chamber of Commerce and Industry. So Shahid Ullah, you should also voice your concern there. And Dhaka Chamber, Shams Mahmud is here. So, you see, this is, I think this is true. I think I agree. A stitch in time saves 9. But in other jurisdictions, I think in the Western world, they will not say a thing without talking to their lawyer, which is the right way of dealing things. But in Bangladesh, we see that you don't go to a lawyer unless you have to. And by the time you go to a lawyer, it's all done. So, it's just like that. So that is what he was referring to. And he was saying that ADR clauses needs to be included. Finally, we heard from Rubaiyah, who spoke from BIAC perspective. She has been dealing with BIAC mediation and arbitration cases. And she said that, well, most of the clients in BIAC, they have LC-related issues and discrepancies, but she has had huge difficulty to start with because they don't even know what they're complaining about. They're just complaining on verbal assurance or oral assurance or a telecommunication confirmation. Now, these certain things are so naive and so immature, if I may use the word, because when there is a dispute, it's all good when we are friends, but it's no longer good because when there is money dispute, we're no longer friends. So it's always better to have a proper formal arrangement, and that is what Rubaiyah also kind of reinforced. I think she went in favor of what Shahid Ullah talked about, that speak to lawyers, get it formalized, get it vetted, and then do it. Lack of paperwork was the thing, and she also mentioned that we should take small steps at one time, baby steps, and her baby step was educating the local businessman about the importance of having it all formalized. We have, in this context, I would like to mention that recently during COVID, all of us know that Bangladesh is one of the highest garments exporter country in the world. I think we are second at the moment. But then during COVID, a lot of contracts got canceled and got renegotiated by the Western world, by the buyers. And one of the reasons why the buyers could do so was because there was no specific properly drafted and properly vetted contracts, and there were no specific force majeure clauses incorporated in the contracts, and also a lack of proper ADR clauses were also there. So I understand that when Bangladesh started their garments industry, or for that matter, international trade and finance, when we started, we were a baby in the league, and then maybe we accepted everything that big brothers had to say. But then I think that attitude needs to change. I'm not saying that we become rude and lose business in the process. It is just knowing where we are, just so that we are confident enough to sit across the table and talk, and let us have a win-win sustainable business relationship. And that can only happen when we give regard to institutional arbitration and ADR clauses incorporated in the contracts, and also the importance of professionals before it's too late. I think that is what the entire panelists have to say. If anyone has any specific comment, please raise your hand and speak on that. Yes, Mr. Zaman. Bhaiya, please unmute yourself and comment on it.
I would just like to make a general comment that when it comes to international LCs, Bangladesh has had issues of payment delays, but not issues of non-payment. I think that's important to bear in mind. And I think whenever we have had, from our perspective, the problems that we have had, it's relating to local LCs. I don't know whether there are other bankers in the panel, whether they would agree with me or not. And it is this delay in non-payment which causes problem. And I would agree that I think banks locally, they take the clearance from their customer before making the payment, even if terms and conditions have been fulfilled. And I think the delays happen for frivolous reasons, and that is to help the customer. The banking community is moving away from that because I think the traditional mode was that it would be handled by the branches. But operations are now being centralized, and the central operation is independent of where the relationship is managed. So that process is also improving, in my humble opinion. Thank you.
Thank you. Thank you, Ahsan Bhai. Yes, Mr. M.S. Siddiqui, your remarks, please.
Yeah, yes. We are talking about the ADR clause in letter of credit. Actually, it is not required. The inherent tradition has the ADR clauses. The gentleman, the banker, managing director of the bank, he says, he was talking about the dog decks. That is the interpretation or definition of the terms and condition of the UCP letter of credit, UCP 600. And there is an additional document prepared by ICC for dispute resolution, only for the interpretation of the letter of credit. So if there is any dispute between two bankers, LC opening and LC transmitting bank, then it can be resolved by ADR set by ICC. So it is already inherent there. So there is no record of additional ADR clause in the letter of credit. Thank you.
Thank you. Anyone else? Is Khaled Aziz, Mr. Khaled Aziz. Vincent, I'll come to you. Mr. Khaled Aziz.
Yeah, I think just very quickly, I would like to agree with Ahsan-uz Zaman bhai. See, I think banking works on an honor system, right? And a UCP basically prescribes a certain number of days within which the payment and everything else should be made. Sometimes there is an intentional delay on part of the bankers. I wouldn't say it's very common, but that does happen. And which actually kind of damages our reputation, not only as bankers, but as a country. So I think that is something which requires attention. Fortunately, I do see a lot of focus from our regulators. Bangladesh Bank, they're particularly very serious about unacceptable delays in payments, which is good. And I would also like to agree with my previous speaker. As I have said earlier, it's very important to keep the letter of credit separate from the commercial contract. I think very clearly the applicability of ADR in the commercial contract, I think all of us have agreed here. In terms of letter of credit, I don't think it's necessary to have a dispute clause built in the letter of credit itself, because there are practices and other references which are already applicable, which governs the contract. So that's what I wanted to add.
Thank you. Thank you, Khaled Bhai. Vincent, over to you.
Yeah, really following on the point Khaled meant just now, and Samir made it earlier on, I've been involved in many arbitration cases as an expert on letters of credit, but actually the cases were actually about the contract, but there was a letter of credit securing the payment. So one of them, for example, was an exporter didn't ship the goods, the importer sued him for breach of contract, but the contract actually said that payment was to be by letter of credit available by site payment, okay? But the letter of credit was available by negotiation of drafts at site drawn on issuing bank. Two different things, but in the mind of the customers, one thought it was one thing, the other was the other. So while it was an LC, was a core component of the dispute, it was really the technical issue regarding the letter of credit. So of course, having a letter of credit stating that any dispute will be subject to arbitration would be something quite alien to the mind of a banker operating under an independent instrument. Now that's kind of the positive side. But again, there's something regarding the environment we're in right now, okay? And that is that discrepancy levels are going up and have gone up, okay, in recent times. There's no doubt about it. Actually, the use of commercial letters issued by SWIFT are going down year on year. Actually, Bangladesh is an exception, okay? But generally, as a world practice, the use is going down. And there is a problem. There's a problem with the product. And the problem is that if a bank finds the documents are discrepant, okay, an issuing bank in Bangladesh or in any country, okay, the documents are discrepant, the goods could be on their way to the country of import or there already, well, it's very convenient way for a bank to escape any payment obligation. That's just the way the product works. And with discrepancy levels very high, And with so many underlying disputes regarding force majeure, et cetera, the product is in a shaky environment. So when we get back to BIAC regarding the dispute resolution, there are lots of importers and exporters unhappy with the way the letter of credit is functioning. So there's two sides to the story. And I think this is a wonderful discussion because we are looking at both sides of the story.
Yes, thank you so much. Vincent, Samir, Sattar, would you like to have some?
Yes, I was just thinking one other aspect, and some of the speakers may have also raised this point, is that we must also bear in mind that we are a closed economy insofar as foreign exchange is concerned. So LC payment, one of the reasons why we opt for payment is that whenever there is a cross-border transaction, we'd like our foreign currency to be coming into Bangladesh in a more secured form. And there is, I think, a Bangladesh Bank guideline of 120 days within which the exporter is bound to bring in the money. And if a dispute resolution clause is inserted in an LC, and if the opportunity is given to raise disputes in relation to this specific issue, it may not necessarily comply with the Bangladesh Bank guidelines of bringing in the foreign currency, the inward remittance to be guaranteed and coming in very quickly. So there are other important areas of law that also plays a very crucial role here. Whenever we are dealing with LC dispute, the banks will also have to bear that in mind, that they have an overriding guidelines which they need to follow. And there's an inherent duty on banks and the exporter to ensure that all these export proceeds are coming in. And I just fear that the ingenuity of lawyers know no bounds. So whenever there is a lawyer who can see that there is an opportunity, and we've seen this, just recently, I was able to vacate an injunction in relation to an LC payment where a certain unscrupulous Bangladeshi buyer had obtained an injunction from a court on an LC payment, and my client was a Singaporean client. And they're like, what happened? Does that actually happen without any grounds? How did they obtain an injunction? And I said that no, there are grounds, but we'll have to apply for a vacating order for that injunction. But when it went to the superior court, the court was very swift in quickly vacating that order of injunction. So once we insert another dispute resolution clause in LC, all you need is a savvy, unscrupulous lawyer saying that, hang on, why don't we delay the payment? Why don't we just file a case and just complicate the matter? And, Vincent was talking about discrepant documents, and yes, there are discrepant documents, and Khaled Bhai and all the bankers were saying that, but bankers tend to resolve that because the UCP itself provides certain provisions in dealing with discrepant documents. And it is up to the banker's discretion as to how much they will allow and how much they can waive that discrepant documents in order to honor the LC. So the sanctity of the LC is here, very paramount in cross-border transactions. So unless it is absolutely fraud and forgery, which is within the bank's knowledge, they do not generally want to stop an LC payment. And I think allowing any other mechanism or any other option for a lawyer to play with that avenue would go against all norms and practices. But again, I know I haven't experienced anything. I haven't seen any disputes relating to LC insofar as arbitration is concerned. But the growing trend is that LC disputes are being arbitrated. People are putting in arbitration clause. Only time will tell how that pans out. And especially in a country like Bangladesh, where so many frivolous claims are entertained at various levels. So we need to be someone needs to be very strict up there, saying that, hang on, here are your costs for trying to stop an LC payment on frivolous grounds. But unless that is there, the whole fabric of, LC payment and international trade may be at jeopardy. But again, those are my thoughts.
Thank you, Mr. Sattar, for again advocating on behalf of that. Just one thing I would like to say from my point. I agree with most of the thing that you said, but only one thing is you said some unscrupulous lawyers can take advantage of the situation. I think maybe some unscrupulous clients who engage lawyers, because lawyers actually
absolutely.
Lawyers as a community, they don't actually do anything. They work. They get hired by, you know.
That's true.
That was an admission by a very noted lawyer.
Yeah, I know.
That's
why I was just correcting, because I
no, that's right. And I'm happy that you corrected it at that point.
You did not mean that, because lawyers are actually your friends, good lawyers. That is, good lawyers are actually your friends.
Absolutely.
So that means there are bad lawyers.
Bad examples are there everywhere. Bad apples are there everywhere. Talk about doctors, engineers, and I can keep on talking. So, but yes, I think we had a fantastic evening talking about this a very, very thought-provoking subject. Now, I would like to go for the closing remarks from none other than Mr. A. Rumee Ali, who himself does not require any introduction. He is an institution by himself. But then again, just for the formality, let me give a short introduction. Mr. Mahmud A. Rumee Ali is the Chief Executive Officer of Bangladesh International Arbitration Center, BIAC, since 2015. He started his career with ANZ Greenlace Bank in Bangladesh in 1975 after completing Masters in Economics from the University of Dhaka. A former Deputy Governor of Bangladesh Bank, Mr. Ali was Chairman of BRAC Bank and CEO of ANZ Greenlace and Standard Chartered Bank, Bangladesh. He specializes in financial industry, strategic thinking, and social enterprise development. Currently, he is also the chairman of AB Bank Limited. So let us hear some closing remarks from Mr. A. Rumee Ali. Over to you, sir.
Thank you, Shafayat, for that introduction. I won't get into the dispute or the debate about a lawyer who is good and who isn't good, but just to wish you all good evening and Assalamu alaikum. I'll start by thanking Mr. Shams Mahmud, the president of Dhaka Chamber of Commerce and Industries, for joining us on this webinar. Thank you very much, Shams. I think this is just the first of other cooperation. And it's particularly a privilege for BIAC because DCCI happens to be one of the sponsor founders of BIAC. I hope we can continue to work together on this area. I'd like to just name our distinguished speakers because I'm really thankful to all of them. Mr. Ahsan-uz Zaman, who I know for a long time, was a colleague of mine in banking. Mr. Vincent O'Brien, who, again, he's the one who doesn't need any introduction in Bangladesh. Almost every banker knows him very well. And he's a sort of a guru of the banking fraternity because he comes here and does all these courses. Mr. Samir Sattar, Barrister Samir Sattar, sorry, correction. Mr. Sattar is a good friend of BIAC. He's always there to join us in webinars, and of course he's a very well-known lawyer. Mr. Khalid Aziz, I hope we can hear more from you at BIAC. Mr. MS Siddiqui, who is a very well-known industrialist, a businessman, and of course an economist too. And he writes excellent articles, which I do read once in a while. And thank you for joining us. And of course, our own Rubaiyat. I hope I didn't miss anybody. Rubaiyat Ehsan for joining us. That was excellent. And Shahid, yes. Mr. Khalid Aziz, Mr. Shahidul Azim, yeah, the barrister. Thank you very much. I thought your intervention was very thought-provoking. Thank you again. And thank you all for being here, because it's very important for the people who are considered, the experts, the people with wisdom, the people with knowledge to speak on the subject, because this gives credibility to what we are trying to do over here. Let me start by telling you, BIAC does not support putting ADR clause in the LC. It doesn't work because, as many has said, and particularly Mr. Samir Sattar, that it is an instrument which should be kept away from the underlying contract between the buyer and the seller. As an ex-banker, I think it is very important to understand that. What BIAC is advocating is that the contract should have, the underlying contract should have a clear ADR contract. The reason, we have been able to, in our own experience with the garment textile industries and with the general, with the, the SMEs in this country, and also the traders, who, Bangladesh is an import-oriented economy. And there's a lot of imports, and also there's a lot of trade within the economy. And the LCs which are done in the international trade and also internal trade, I've seen most of them do not have an underlying contract. Even in the very evolved industry of the garment and textile industry, our own experience has been they have a contract, but they don't have an ADR clause. And that way they cannot solve. And recently you saw what happened when many of the very well-known big companies walked away from the contract, citing frivolous force majeure clauses, which of course many of them revoked later on. So I think, what we are saying is that you must have a contract. Please have a contract, because in some cases we have seen the only thing on which they opened the contract was a pro forma invoice, not even a full invoice, a pro forma invoice. And they took the pro forma invoice to the banker and they opened the LC with that. Here, I must also call on the bankers to be a little more careful about it and ask them, do you have a contract? Particularly when they are financing it, financing the whole industry or that whole trade. It could well be because they don't have, the customer won't have any remedy for some issue where they have got the wrong goods or not the right type of goods or whatever, not got the payment. There you don't have a remedy through the legal system, because under the LC, you will not likely to get an injunction or anything. So it is better to have it where in your contract, and that's what we are talking about over here. The whole, we put that caption over there to bring all the people together to actually talk, make it sound controversial so that people take interest. And I saw we evoked that interest. So that I think was a good strategy to put that in over there. I can see Shafayat, nodding his head in agreement. Thank you, Shafayat, for endorsing that. So we need to actually resolve this issue because, as I said, we have the huge industry, the garment textile industry, where this is very important for them. We have our small and medium enterprises, which are more and more evolving, and they're starting to use local letters of credit. And I think we need to put this in our local letter of credit. Don't put ADR clause on the credit. Talk to the customers, tell them that have a contract and put the ADR clause there. So in case you have a dispute, you can go to BIAC. That's my commercial, come to BIAC. So I think, we are here at BIAC to assist you. If you do have a dispute, we'll try to help you. Even if you don't have an ADR clause now, come to us. We'll see if the other party, both the parties agree. We have had cases where both parties later on agree to an arbitration. They have, sometimes we try to steer them towards mediation, which works best. But, mediation in our country still lacks credibility. So they prefer arbitration, which is all right. It's the first step in the world. With many, in my discussions with other countries, ADR institutions, they have all said that we started with arbitration first, and mediation was a later step. And now we are doing more mediations. So I think we'll go through that transition also, but we have to start somewhere. And I think it is very important for us to start somewhere because we are becoming a big economy, a much bigger economy, because we are thinking of moving out from the least developed country into a developing country. And that will mean a huge increase in our GDP. And the GDP relies on transactions. And the transactions rely on letters of credit, some some sort of payment, and most likely letters of credit or some payment mechanism, which means more disputes. Which means if you want to avoid the delay and have an efficient process of resolving it, you have to have an ADR clause. So to my friends who are in the banking industry and my friends who are lawyers, all lawyers are great. We don't have a bad lawyer. This is to make lawyers, look at ADR. So do come to us. We are there to support you and help you and assist you to do it in a very professional way. With those words, I have to thank all of you again for being patient on a holiday and coming over here to talk on this issue. Thank you very much. We'll see you again soon, inshallah.
Thank you, everyone. Rumee, thank you so much.
Thank you very much. Wonderful.
Thank you.
Thank you.
Thank you, everyone. Thank you, Shafayat bhai,
Bye-bye.
Thank you, everybody.
for everything.
Thank you. Assalamu alaikum.
Assalamu alaikum.
Thank you all.